one are not only moot but are actually undesirable.
The Honourable Chester Borrows.
Thank you, Mr. Chairman. And just in response to the points that have been made, it's interesting, or it's pertinent to note that where the genesis of this provision came from was the fact that technology had moved faster than the law had, and so law enforcement agencies were able to draw on new abilities that were given by new technologies, and so were using those in investigations where it was questionable whether or not there was the ability to do so. In response to the query raised in respect of declaratory orders, the point has been made that they are advisory, and I understand the point that the member has made. It is up to the courts to determine the impact of the Harmad decision in respect of that declaratory judgment, and then in subsequent matters as raised before them case by case. As the member Charles Chevelle noted, the declaratory order regime was recast from the residual warrant regime by the Justice and Electoral Committee when they considered the bill. And I should note that declaratory orders do not give the police or any other enforcement officers new powers. However, as I will come back to in a moment, the regime future-proofs the bill by enabling enforcement agencies to undertake investigation of a crime in the modern era while keeping pace with technological advancement, which is a provision that hasn't been available in the past. Declaratory orders will be made ex parte, in other words, as with application for warrants on the papers and without notice to another party. And there will be no adversarial process, and the only respondent in a case involving declaratory orders would be the person for whom against the proposed device or technique or procedure was going to be used. And so by giving them the opportunity to speak, obviously we would be or the police or the courts would be forewarning them of the interest, and so would be stymieing the whole need for the application for the declaratory judgment. As noted by the member, declaratory orders are advisory in nature and can be made by either a district court or a high court judge. However, they are persuasive. It's inappropriate that declaratory orders should be binding, as at a later date a court will have the benefits of all the facts and the context in relation to the actual use of the device as used at an earlier stage. And that is the point that was made by the Honourable Member Charles Chevelle, in that the declaratory order is around a hypothetical matter, but the later subsequent court case will be about actual facts for which the courts will have to make their own decision, albeit in light of the declaratory judgment made on the earlier application.
The Honourable David Parker.
Mr. Chairman.